Hi, welcome to the review of the midterm. We'll go through this pretty quickly. Part 1, Section 1.1. HHI stands for what term? That's Herfindahl Index. I'm not going to write it out. It's too hard for me to do. Long story. Number 2, what is the standard for judging price fixing and bid rigging under the PCA? It is the per se standard. Number 1.3. Rather than being considered illegal by their very nature or object, most vertical agreements under EU jurisprudence are considered illegal only if they have a substantial effect on competition. I was looking for the word effect. That was the key. The difference between object and effect type violations is very, very important under EU jurisprudence. Number 1.4. Under the PCA, a firm will be presumed to hold a dominant position if it has share equal to what percentage or greater? That is 50%. That's from the PCA. Remember, that's only a presumption, and it also could be changed by the PCC later on. 1.5. Under which two treaty articles, old and new, would one find the provisions on holding and abusing a dominant position? Those are Articles 82 and 102. 1.6. According to Professor Levmore, what do economists call a market inefficiency created when rational pricing reduces supply in order to maximize profit? That is deadweight loss. Number 1.7. In the screencast on market definition, Prof. Dan talked about an unusual sounding term that describes an error sometimes made by courts with respect to assessing relevant markets too broadly. That is the cellophane fallacy. 1.8. Sometimes when a consumer buys something, he or she says, "Boy, I would have paid much more for that. What a bargain I got." Economists describe the difference between what a consumer actually pays and what he would have paid for something as consumer surplus. Part 2. Here we're thinking about a situation where there are draft IRRs being developed, and we have a few questions. Assuming that the following titles of sections of the IRRs accurately reflect their content, which would be most vulnerable to challenges on grounds of going outside the scope of the law? Let's see here. Agreements that are considered illegal by object under Section 14 is not the correct answer. That would certainly be something that we would want to see in IRRs. B. Methods for establishing the appropriate level of cost under Section 15. Also something very good and useful under IRRs. C. Criteria for determining whether a producer or service provider is marginalized under Section 15 of the Act. That also is an open question under Section 15, so that would probably be okay, and would be good to see something there in the IRRs. And then the last one, D, protection of competitors from larger and more efficient firms under Section 15 of the Act. This is the one that is probably outside the scope of the law. The PCA is not supposed to protect smaller and less efficient companies. If there's anything PCA should be about, it's competition on the merits. And if a large company can outcompete a smaller company on the merits, then it should not be held liable. It all comes down to when larger companies use things other than the merits, such as their size or their strength in the market, to beat another company that may be actually performing better. That's when you can think about how the PCA may apply. 2.2. Under which of the following sections of the Act might the IRRs establish criteria for balancing enhanced efficiency against consumer interest when they conflict? A, the section on per se violations. Not really. That per se violations means you don't think about those issues. B, the section on exemptions from prohibited mergers. That's the answer. That's where you do the trade-off between enhanced efficiency and consumer interests, especially with regard to the efficiencies defense. 2.3. Under which of the following sections of the Act might the IRRs establish criteria for balancing contractual stability against the potential competitive harms certain contracts might cause? We talked a lot about this issue. 14A is not a place where balancing occurs. Those types of agreements, price fixing, bid rigging, are not subject to any kind of balancing. Section 15 has nothing to do with contracts. It's all about dominant firms. The correct answer is 14C. That's where all the real balancing occurs. And that's a section where essentially we're deciding whether the effects of a particular agreement have negative on the market. Part 3 is the first time you're seeing a scenario. The scenario is based on a recent acquisition of Holcim by Lafarge. These are two cement companies that have been competing around the world, and they have competition in the Philippines, but that is soon going to be going away. Question 3.1, true or false? Although Chapter 4 deals with mergers only, it is possible that the substantial equivalence doctrine used in the U.S. and the EU could be applied in the Philippines to nevertheless require that the parties obtain PCA approval prior to finalization. What's going on here is that the transaction in question is not a merger. It is an acquisition of assets. This question is essentially leading you down the path of thinking that PCA only deals with mergers and not acquisitions. In fact, it deals with both mergers and acquisitions. So the correct answer here is false. The Chapter 4 does not deal with mergers only, and I'm not aware of anything called the substantial equivalence doctrine used in the EU or the US to essentially allow acquisitions to be somehow considered to be the equivalent of mergers. What goes on is both the EU and the US both consider acquisitions to be mergers and essentially regulate them. Question 3.2. This is a sequencing exercise where you take the steps below and put them in the correct order in accordance with what the law and common sense requires. First step is, on the basis of the notification criteria in the Act, the parties formally notify the PCA, yada, yada, yada. Number 2, the PCA determines the products and services that overlap between Holcim and the Lafarge businesses. That's the first thing David Evans told you to do in his video on the SNP. Figure out the common products or services. Number 3, the economists conduct a SNP test on the overlapping products and services. Number 4, the PCA determines the relevant product market. Number 5, the PCA determines the relevant geographic market. You cannot do the geographic market until you figure out the product market. Number 6, the PCA calculates the HHIs of the various market participants prior to the transaction. Number 7, the PCA calculates the HHIs of the various market participants after the transaction. So what we're doing there is we're setting up what you call the deltas, the differences between the pre-merger HHIs and the post-merger HHIs, which leads to 8. Well, at the bottom, the PCA calculates the differences in the HHIs. Moving up for 9, the PCA considers unilateral and coordinated effects of the mergers in the event it is allowed to proceed. We know that unilateral effects is essentially how the company would act as for a dominant firm, and we know that coordinated effects is the possibility that collusion could occur in a market that has become more concentrated after the merger. 10. The PCA raises objections to the merger on grounds that it might substantially prevent or restrict or lessen competition. It should be the PCC raises objections. I keep making that mistake, and I'm sorry about it. Number 11 is right below it. The merging parties come back and say that the gains and efficiencies outweigh the negative effects of competition. The PCA rejects the greater efficiencies defense. That's number 12. This is where the remedies come in. The parties and the Irish investor agree for it to acquire a greater portion of the assets of the Lafarge industry subsidiary. What's going on here is that we are trying to minimize the effect on competition so that the gains and efficiencies outweigh those effects on competition, or to minimize the harm to competition such that it's no longer considered to be a substantial lessening of competition. 14. The PCA recalculates the post-deal HHI and the possible ramifications on unilateral and competitive effects under the adjusted transaction, which is basically going back to square one, but with a slightly different deal. And 15, the PCA determines that by virtue of the adjustments offered by the parties to the merger deal, finds it unlikely to substantially prevent, restrict, or lessen competition. Again, I said PCC when I said PCA when I really meant PCC. Part 4. This one brought forth a scenario of a dominant firm and how it is dealing with an upstart competitor. 4.1. Assuming that the relevant product market is no broader than cigarettes, what definition of the relevant product market would be most helpful to FMPT's case? What's clear here is that FMPT is in a dominant position with respect to the entire cigarette market. However, what they're going to argue is that within a smaller segment of that broader market, they are not dominant. And if there was a determination that the low-cost cigarettes were considered to be a relevant product market unto itself, then suddenly FMPT does not have a substantial share of that market and may very well not be considered dominant. This is an example of how litigants will play with definition of markets in order to cast themselves in the most favorable light under the law. 4.2. Here I list out a bunch of factors under Section 27 of the PCA. I ask you to assume that the relevant product market is deemed to be all cigarettes, and I ask which of the three-lettered factors might get the FMPT out of its presumption that it enjoys a dominant position. Basically, if you answered B, C, D, or E, I will give you points. If you considered F or A, I will probably subtract some points. The reason why A and F do not really matter, we've already clarified what the share of the market is. It doesn't help FMPT at all. And with its recent conducts, you could probably argue that its aggressive pricing against its competitor hurts it. So the other answers are much better. In B, FMPT can argue that there are no barriers to entry because we're having competitors come in. And its competitor is very powerful since it seems to have good connections up in Lausanne and also might have good connections with the BIR. D, clearly competitors have resources to inputs that it has up in Lausanne with all the tobacco farmers. And then finally, E, the power of its customers to switch to other goods or services. That was demonstrated in the scenario when customers switched over to the new cigarette away from Marlboro Black. 4.3. What two subsections of Section 15 on abuse are most closely implicated by the facts described in the cigarette scenario? You could have written numbers of subsections. You could have come up with labels. And I'm just going to describe the labels. Clearly, the label that is applied or that is implicated here is something called predatory pricing. That is pricing below a certain level of cost in an effort to drive out your competitor in order to raise prices thereafter. It's tougher is the second one. And probably the best answer there is price discrimination. That's the use of different types of price discounts in order to selectively exert market power over a particular market. Next one, 4.4. Which of the following legal inquiries would be the least helpful for the PCC in resolving this case? Okay, let's go through them. A, the appropriate method of determining the cost of producing FMPT cigarettes. That's a very important legal inquiry. There are many different ways to measure cost. And depending on which method you choose, it's possible that FMPT did or did not price below that level of cost. So that is an extremely important legal inquiry. And so hence that is not the answer. B, whether a rebate is the legal equivalent of a price cut. That also is a legal question, and it is very important because what was going on was that the prices weren't cut in this scenario. They were basically reduced after the fact in the form of rebates. So whether that's the same as pricing, most countries it is, but it might be a legal question here. C, whether a dominant firm needs to be dominant in both the market of the tying product and the market of the tied product. This is not a tying question, and as a result, C is the least helpful legal inquiry in resolving this case. 4.5. Which of the following factual issues, if resolved, would be the most helpful for the PCC in resolving this case quickly? The answer here is A, whether the price of Marlboro Black was not in fact below the legally appropriate cost of producing it. There are many different elements in a predatory pricing case, but the most important one that is without a doubt required is pricing below cost. And if you don't do that, you cannot be considered to be predatorily pricing, even if you have some very strong and hateful motives behind it. Moving on, 4.6. Assume that FMPT's prices for Marlboro were found to be below the legally appropriate level of cost for producing them. Which of the following statements, if supported by substantial evidence, might be helpful to FMPT? Okay, let's look at some of the answers here. Let's start with B, that the prices of Marlboro Black never went below those of MIT Smokes during the period in question. That is not terribly helpful because it might be possible that Marlboros are a few cents above the price of MIT's, but Marlboro is nevertheless below its own cost. In which case, it does not matter whether the prices are below the competitor. The key is the relationship between the producer's price and the producer's cost. The producer's price needs to be below the producer's cost in order to be considered illegal. The price of the competitor that is being predated upon is not necessarily an issue. Let's look at C. That in several emails, corporate executives of FMPT had discussed the need to squash MIT and give them a lesson they will soon forget. That's certainly not helpful to FMPT at all. And it may or may not be harmful depending on other elements of the case. And let's look at A. That despite substantial non-transitory increases in the price of the low-cost cigarette segment, very few customers would switch to mid-market brands whose prices are now closer to the low-cost segment. What I'm going about here is trying to put out for you and hope you recognize that this essentially means that there is a sub-market for low-cost cigarettes, in which case FMPT is probably not in a dominant position, and therefore its pricing behavior doesn't matter. So that would be the most helpful of the answers. That's A. 5, evaluating complaints of collusion. This is the roaming question scenario that I presented to you. I know it's pretty detailed. Let's go down to the questions. If the goal of the PCC were to resolve this investigation as soon as possible, the least cost to the parties, what might it consider doing? These early outs for cases are extremely important because you as perhaps a defender or a lawyer with a client who is being accused of some sort of malfeasance under the PCA should look for easy ways to resolve cases as opposed to getting into long, grinding discussions and investigations as to the intent of the parties or the cost data that the parties had. These are the kinds of things that could drag on for years. So where's the quick bullet to get to resolve this case as soon as possible? And the answer there is D, evaluating various structural aspects of the market in which the collusion occurred to determine whether the collusion was even economically plausible. It's impossible to collude effectively in a very competitive market. And if there is no direct evidence of such collusion, which if there were, maybe you could still bring it under a price fixing case because it's considered to be per se illegal. But without any kind of direct smoking gun, if we're looking at trying to prove collusion through circumstantial evidence, certainly evidence that the market is one where collusion does not make sense or could never work is a very, very strong piece of evidence for vindicating your client and getting him out of trouble. So the answer to 5.1 is D. 5.2. An important factor in World and Quick's defense is that the movement to the fixed daily rate by the two companies increased competition, thereby making opportunities for collusion less likely to succeed. The answer there is false. It was very important that World and Quick came to essentially a common pattern of offering prices to customers. That made it exceedingly more easy to collude or possibly collude when they have a common price on which to agree to fix or hold their prices even when their costs are dropping. 5.3. Minutes from a board meeting of Quick have been leaked. They reflected a discussion in 2016 in which a plan to roll out a new Quick Roamer Pick pricing plan at $4.99 per day was considered and discarded. One particular quote from the minutes received headline attention. "I am sorry, but I read the new Competition Act," one director stated. "Nowhere does it say we are required to always compete everywhere with our competitors." Now, if that got into the headlines, I could see that making big noise, and that could be the death sentence for at least Quick. But if you more closely look at what oligopolists do, it's probably not the death knell for Quick. So A, game over, World and Quick lose. That is not the correct answer, because what is stated there is not an agreement, is not an acknowledgement of an agreement between World and Quick to keep prices up. The correct answer is most likely B. Aside from its unfortunate headline effects, the statement is nevertheless true. They do not have to compete always, all the time, with everybody. It should be of little consequence to the PCC if it understands how companies in oligopolistic markets act and react to each other. So the best answer here is B. C is also says that there's no impact on the proceedings, but the basis for that is incorrect, because no impact because price fixing agreements need to be explicit, if not on paper, or otherwise recorded on tape. No, that's certainly not the answer. Moving on. 5.4. Regardless of its implications, the statement in the board minutes described above is an example of, this one's pretty easy, it is A, circumstantial evidence. The answer is even in the question, regardless of its implications. Circumstantial evidence is all about implications. 5.5. During the proceedings, World introduces evidence that a major factor of being able to offer the $5.99 rate to its customers in 2014 was because it had entered into long-term contracts with its overseas telecom partners that offered the services to World customers in other countries. So what we have here is World has entered into long-term contracts. This might have a major effect on how it can price going in the period during the contract. So let's take a look and see if that might have some vindicating effect. The correct answer is A. In order to obtain the discount on wholesale data services from its overseas partners, World had to commit to accessing these services exclusively at rates that would remain constant through 2018. Here, World is choosing an arrangement where its prices in the future are set for a while, but it's probably getting a discount up front. This is a very reasonable decision. It's made by parties in the markets all the time. It's essentially hedging against price volatility. And World chose that here, and that would be the fact that such a contract locked its costs in for a while in exchange for a discount is going to be very helpful to its defense in that for why it was keeping its prices constant when the rest of the industry perhaps was having reduced costs. The others are far less helpful. B imagines a flexible pricing mechanism, and that would not help World at all in its defense because even though it would have a flexible pricing mechanism, or flexible costs, it nevertheless kept its prices constant. So that doesn't help it at all. And C, the contracts could be terminated with 90 days. That is also not helpful because one could argue that if World had lower costs out there, or lower opportunities for lower costs, it could terminate its contract with its current service providers and look for something else. And then D, the contracts lacked any provision that prohibited the suppliers from dealing with Quick is not really relevant to the costs that World was having during the period. 5.6. Here's a statement by one of World's executives. Sure, we explained our long-term deals with the overseas partners to Quick. They were negotiating with the same providers, and we knew how difficult it was to deal with those Singaporean and Dubai companies. We Philippine companies have to stick together out there. Plus, Quick was negotiating in some countries where we had not yet entered, and they promised to return the favor for us. This is a very damaging statement for World Communications. So the correct answer is B. It will hurt World's efforts. Essentially, the executive is conceding that they are exchanging information about future prices. This is something that competitors in oligopolistic markets should not do. And if they do so, and we see afterwards evidence of pricing parallelism, that helps you develop a very strong case against the companies that were exchanging information about pricing. So long and short of it, you go ahead and exchange information about pricing and in the future, and then you both maintain those prices in the future. From those two data points, you can infer that there was an agreement between the two parties to keep the prices at the rates that were exchanged. So to just clarify again, the answer is B. It will hurt World's efforts to have the proceedings closed with no finding of liability. 5.7. During the investigation, the PCC determines that in 2015 and 2016, various telecom service providers had increasingly offered travelers from other countries an opportunity to use local SIM cards and enjoy data services at rates in local currency substantially below the $5.99 deal offered by World and Quick. What kind of impact is this likely to have on the proceedings? This is a question that is focusing on the market structure aspect of a case against oligopolies based on circumstantial evidence. It's essentially saying that perhaps the market is so open that collusion wouldn't make any sense between World and Quick when there are so many other competitors out there with their cheap SIM cards that any kind of price fixing by World and Quick would make absolutely no sense because they'll be undercut by these competitors. The answer here is a little tough. The nuanced answer is C. The impact will depend on the extent that World and Quick subscribers are using phones where the SIM card were locked. Now, yes, it's quite possible that a bunch of customers are more flexible, but what might very well be happening here is that World and Quick have identified a particular subset of customers, i.e. subscribers with locked phones, and are price fixing in that particular, with respect to those particular customers. Now, you didn't read this case, but there is a case called RE text messaging, and it's another collusion case, and it was decided by Judge Posner. I will post that case on Facebook. It would be an interesting one to read, and it's extremely well written. It was a source of a lot of the thinking that came behind this particular exam question. Part 6, evaluating complaints that the PBA's joint marketing venture is harming competition. Here you had the benefit of me developing online a scenario very similar to this one. So if you watched my walkthrough of one of the handouts, you should do okay in this particular scenario. So we have the PBA deciding to establish one sole marketer and producer of its PBA apparel. And as a result, Pro Shirts gets frozen out of this deal and is not happy and decides to sue, or at least decides to complain to the PCC. So let's go through the short answers. The EU oftentimes uses a counterfactual to help measure the loss to competition caused by a particular practice. In this scenario, what would be the counterfactual? Here, the counterfactual is the level of competition before this particular practice went into effect with the single supplier of PBA apparel. So by comparing what happened, what was the situation before versus the situation now with the new arrangement with the PBA exclusive supplier, the authorities can measure the harm to competition caused by the particular practice. Okay, 6.2. This question asks you about relevant markets. Describe a possible market that would be helpful to the complaint that Pro Sports is making if the PCC adopted it as the correct relevant market for this case. So what kind of market helps Pro Sports? You want a very narrow market, and that narrow market has to be essentially PBA labeled clothing. If consumers would essentially be trapped by their desire to have PBA apparel and would pay bigger prices because of it, then the Pro Sports may very well have a case. However, if nobody really cares whether a PBA team name is on a shirt, and for them sports clothes is sports clothes, and they're looking for the quality of the fabric and the price, and logo means nothing, then it's much harder for Pro Sports to make an argument that this agreement has somehow harmed competition. I got this from the NFL case, and it was very important to the court there that we saw price increases for the NFL branded apparel after the arrangement was established. So if there's no effect on competition and a competitor is harmed, the competition laws are not necessarily supposed to do anything about it. But here, the link needs to be made between a harm to competition and a harm to a particular competitor. And that's where Pro Sports needs to argue that the market is very limited and that there was an impact on this particular market. 6.3. The arrangement of the scenario has both vertical and horizontal elements to it. It would be more helpful to Pro Sports' case if the PCC focused on the vertical elements. That is false. The key here would be to cast this arrangement as an agreement among competitors not to compete with each other. If that's possible, then Pro Sports has moved very, very close to prevailing in the case. Okay, and then the final question, I asked you to try to explain to me where you're the most confused. That's essentially one of my goals in this exam, is to see where you guys are in your understanding of the various concepts I've given you. But in addition to seeing that through the questions themselves, I've asked you to essentially lay out the area where you're most confused and where you might need more help. And I will look at those when I get a chance, and I might very well put something up on Zaption regarding it. So thank you very much. I hope you all did well. I'll see you in a few weeks.